Prosecutorial misconduct is what it sounds like. It's when the prosecutor misbehaves to an extent where the prejudice is so overwhelming of what he or she did that the fairness is gone. It's a due process thing. It's a protection thing. Let me give you an example. Let's say at trial, the prosecutor in her closing argument says, "Members of the jury, you know the defendant's guilty because he wouldn't get up here and tell you his side of the story." Not allowed to do that. Not allowed to do that, right? A defendant has the right to remain silent throughout trial. It's a Griffin error, and that's prosecutorial misconduct. Another example is a DA says to a defense witness, "I know you're here illegally, and if you testify, I'm going to make sure that the authorities know about it." Obviously, prosecutorial misconduct. Let's say at a 402 ruling, which is pretrial rulings, there's a tape, a 911 tape, say. But the judge says, you know what, the 911 tape is not admissible. During trial, the prosecutor mentions the 911 tape and what it says. Prosecutorial misconduct. So prosecutorial misconduct is basically when the prosecutor does something they're not supposed to do. But that doesn't necessarily mean anything. The prosecution can get away with it unless it's prejudicial. And then it has to be prejudicial to such a degree that it cannot be cured. A lot of times the prosecutor may say something they're not allowed to say, and the judge can either strike it from the record or tell the jury to disregard. The effect of prosecutorial misconduct is that usually someone has been prejudiced, okay? Whether it's the jury because they were told something they're not allowed to hear, or it's the defendant because now the jury knows something that they're not supposed to know. So the effects of prosecutorial misconduct is basically things have become unfair. And the whole point of due process, and in my opinion, the definition of justice, is fairness. So with prosecutorial misconduct, you have a direct affront to fairness. So the effects can be far-ranging. The prosecutor may say something they're not allowed to say, and then it's up to the judge, right? So depending on what the judge does, whether the judge just cures it with a jury instruction or declares a mistrial and you start from the beginning, it all depends on what was said and primarily depends on how much prejudice did it cause. So what do you do if there is prosecutorial misconduct as a defense attorney? Well, let's assume that it's happening during trial, because technically it can happen before trial. The prosecutor doesn't give over some evidence. The prosecutor says something inappropriate to a witness, but it usually happens at trial, right? So let's say the prosecutor says something to the jury they're not allowed to say. Well, as a defense attorney, you have to be thinking like a boxer and a chess player. You have to evaluate just how damaging it is. And that's the chess game, right? I mean, can this jury still look at your client in a way where they may give him the benefit of the doubt now that they know something? Let's say it's a prior conviction for the same thing that the judge said can't come in. If it is that damaging, then the boxer gets up and pounds on the table and demands a new trial. But let's say it happens, but you like how the trial's going. You don't necessarily want to start all over. And a lot of times the client sure doesn't want to start all over. Well, then the boxer can save it for closing argument. And in closing argument, hammer the DA for the inappropriate comment. Hammer the DA that because they don't have the evidence, they're coming up with whatever they can. And it's a shame that they have to resort to such a level to try to blindly lead you somewhere that you're not even allowed to go. So you can use it in your defense, but if it's too prejudicial, you got to fight for a new trial.